Okay, great. Well, welcome everybody to this month's webinar, and we'll be covering today the legal aspects of starting an online business. I'm Alex. I am the co-founder of Sprintlaw. Before we get into the educational materials for today, just to quickly introduce Sprintlaw to those who are not already clients and have not worked with us. We're an online law firm really made to help startups and small businesses access easy, affordable legal services. The way we work is quite different to traditional law firms. We are completely fixed fee, upfront, transparent pricing. We don't charge by the hour, and we cover services in all the different areas of law that you may need help with. Everything from setting up your business, protecting your intellectual property, contracts, employment, privacy. Pretty much all areas of law, we got it covered. We have an optional membership subscription. About 90% of customers sign up to it because it's quite affordable. We've actually just given it a major upgrade about 6 weeks ago, and it's a great way to kind of manage your ongoing legal compliance. Beyond specific services you may need help with. You can book unlimited quick calls with our lawyers when you have questions. We have some AI tools in there for quick support. We monitor your legal health, and we can tell you of those kind of unknown legal risks that might come up with your business. And there's a bunch of other great features as well. So definitely feel free to check that out. There's a free version available on our website if you just want to give it a try before you sign up. A bit more about the team, a bit over 50 people, a bit over 7,000 clients now, actually. Lots of happy customers and lots of industry awards. And we're originally from Australia, but have expanded over to the UK and New Zealand as well. So definitely one of the fast growing and exciting businesses in this space. And if after the end of this session, you are gripped by the inexplicable urge to get some legal help, we offer free consults, and you can use this link. We'll drop some stuff in the chat too. We'll also send out an email as well with some links afterwards as to how to get in touch. Our team are very happy to chat to you about your business's specific needs and give you quotes if there are services and things you need as well. So for today's session, we're going to be covering really a lot of the essential areas of law you want to be familiar with if you are operating or setting up an online business. Really a lot of this stuff will be applicable to anyone operating in any way online, whether you're a service business, a goods business, whether you're just a pure e-com or doing something a little more sophisticated, or even if you're an offline business with online elements. We'll be covering, first of all, basic stuff about setting up the business. How do you register? How do you get started? We'll talk a little bit about the regulations. What are the laws that you need to be aware of when you're setting up your business and when you're selling things online? Intellectual property. How do you protect your brand name, your key assets, your designs, domain registration, all that kind of stuff. We'll go into documents. What are the docs that you need? What are the key contracts that you might want to get in place for your online business? And finally, we'll touch on data and privacy. As I'm going through, we do have a Q&A feature in Zoom. Do feel free to drop questions if you have questions about specific things that I'm covering. I'll try, if I can, to answer them as they come up. And then if there's a few left over, we can cover them off at the end. So let's get into it. Before I start talking about all of these 5 areas, though, I always like to start a lot of my presentations just by talking about this risk matrix with legal support. If you are a smaller business, you don't have unlimited money to spend on lawyers, so the question is, what are you going to spend your time on and sort of spend time investing in? And I think it's useful to attend sessions like this and self-educate so you get good at spotting potential legal risks and legal areas in your business. But B, also thinking about legal risks in terms of how big is this risk, and how likely is this risk to come to fruition. Big organizations, they have in-house lawyers, they'll have internal policies, HR departments, very comprehensive reviews of every document they signed. For a small business, it's just not practical to have that level of legal support. But what you want to think about is, what are the key things I need where if I don't have this, it could be a really big risk. Things which we'll talk about today, like your customer agreements, your terms and conditions. Every single customer is transacting with you. Having at least a document covering how that works, eventually something's likely to go wrong if you don't have something in place. So the likelihood's high and the risk could be severe if there's a problem with your good or service. So that might be a lot more important than an internal social media usage policy for you and one staff member. That may be a low risk, unlikely to cause a problem kind of legal document. So be thinking about that as I'm talking. Some of it's generic in terms of how you think about this. Some of it's specific to your business. And what we find is, very small businesses begin just covering off the red stuff. And as you get larger, you cover off the orange and the yellow stuff. And what we're really trying to do with a lot of the legal stuff is reduce the risk in your business. That's why a lot of people invest in legals. We'll talk about different examples of that today, but it's really about if things go wrong, I want to be protected, or I want to prevent things going wrong by having legal tools in place to do that. A second aspect, of course, is law is not just about risk management, and larger organizations know that speaking to lawyers when you got really big deals happening it can actually get you a better outcome. It can increase your revenue. It can reduce your costs. It can have a really quite a big impact on the business in other ways. And so if you're doing big deals, maybe it's a big supply deal for the goods that you're going to be selling online, you might consider investing in some legal advice on it. Not necessarily because it'll reduce the risk, although it may do that, but because lawyers might be able to help you structure creative arrangements that actually are better for your business. Things we've done before, particularly with e-commerce vendors, they'll have a key supplier, maybe it's an offshore supplier or an onshore supplier. They are agreeing how much they're going to pay for a particular product that they're going to be then selling online. What happens if there's delays in the product coming? Well, there's ways you can negotiate discounted rates for stock when there's issues with delivery, which might not be in the standard contract, but if you saw a lawyer when you negotiate it, you can actually make a better deal that makes you money or saves you money if things do go wrong. So, that's another reason you might consider investing in legal help. So keep that in the back of your mind as we're going through the specifics, but I think it's a useful way for people to understand, when you might need lawyers in your business and when you might not bother making the investment. So let's start with the setup of a business. Some of you may not have set up your online business yet. Others may already be operating. We'll start with a basic distinction. When you are setting up a business, if you're conducting commercial activities in Australia, you need to be registered. If you don't have a registration of some sort, as a business, you're potentially breaching a law. There are many different what we call structures when you go through that registration process that you can choose. You can set yourself up as what's called a sole trader, which is very simple. You just go online, you say, this person, I'm going to start conducting business activities. I'd like to register what's called an Australian business number to register the fact that I'm conducting business activities. You can do that quick, easy online for free. And then off you go, you can start doing business, selling goods, selling services. As you collect income from those services, that firm is part of your personal income. You'll file as part of your tax return at the end of the year. And many people choose to operate in this way because it's fairly straightforward. This is risky though, and most lawyers would recommend, even though it is very simple, if you're operating a serious business, not necessarily going with that simple structure, but considering setting up what we have on the right of screen, which is a company structure. Now, the big advantage of having a company is that you benefit from what's called limited liability. And that means if something goes wrong in your business while you're conducting those business activities, a customer sues you, someone gets hurt, they raise a complaint, they may be able to sue the company, which is kind of set up as a fictional legal person that's separate from you. But you as a potential owner of that company, being what we would call a director or shareholder, and I'll explain the difference in a moment, is typically not liable for issues that occur in the business. Whereas if you're a sole trader, something goes wrong with a customer, something goes wrong when you're selling stuff online, someone tries to sue you, the law will not distinguish between you as a business person and you as an individual. And so all of your assets, your house, your car, your electric guitars, whatever it is that you own, is potentially on the line to a customer of your business. So there's no shield between your business and you as a person. And this is why we as lawyers don't love the sole trader structure. If you're doing a hobby business, a side business, very early stage, it is free, it is cheap, it is quick. If there's not much risk, if everything you do is in the bottom right-hand corner of this risk matrix, maybe. And there are insurances you can get that can help a little bit as a sole trader that provide some protection. But ultimately, you're an individual and a business person in kind of one spot. So this company, you can view it as a shield between your business life and your personal life, and it's a really great way to really reduce a whole host of risks that might occur in your business. Now, when you have a company, you got to choose who's going to be the director of the company, who's going to be the shareholder. You can think of the directors almost as the mind of the company. They're the ones. If you think of a company as a fictional legal person, the directors are the ones who will, be able to sign documents on behalf of that fictional legal person, open bank accounts on behalf of that fictional legal person. They kind of control this fictional legal person called the company. The shareholders, you can think of as kind of the body of that fictional legal person. The analogy breaks down a little, but they can kind of appoint the directors, but in general, they kind of own it, but they don't necessarily control it, if that makes sense. And typically, if you're one person setting up a business or two founders, in the early days, you'll be both the directors and the shareholders. As your business gets bigger, you might take on investors who own a piece of the company but have no control of the day-to-day, or vice versa, directors that help with the day-to-day but don't own much of the company. And so that distinction between the two becomes more significant. But for many online businesses operating at smaller scales, it's a one-person company who's both the shareholder, the director, and they've set it up very much as a shield between themselves and the kind of business risks. So that's the basic distinction. There are other structures like partnerships, which I don't have on screen here. You can think of partnerships almost like multiple sole traders working together. Again, it's not a structure that lawyers particularly like. Law firms themselves, as an aside, are often required to set up as partnerships, which people may have heard of. But that's not because they want to set up as partnerships. Lawyers would love to hide behind company structures, but there are regulations that force them to operate under partner-like models, or what we call incorporated legal practice models. So you do see partnerships out there, but in general they're risky because ultimately it's almost like being two or three sole traders banded together. If something goes wrong in the business, each partner can be liable, if it's two of them, 50-50 for their personal assets. There's no clear separation between the business of the partners and the individuals. So that's why we always, as lawyers, try and push people towards considering company structures. There are more sophisticated company structures out there. I won't spend tons of time on this because we could be here all hour just talking about company structures. But for those setting up a company, the simplest option is to just have one company. If you are growing your business internationally, or you want to raise investment or really scale up the business, you can use these things called dual or multi-company structures, where instead of having one company, you split it into two companies and you get a form of kind of double unlimited liability. So you've got your one fictional legal person, your operating company, it goes out, it employs people, it has customers, it signs contracts. But then it's owned by another company that holds all of your money and all of your business's IP. And so, if your business itself has valuable assets, you may not want it to be on the line to every customer that you talk to. And so oftentimes businesses will have two layers of protection. If something goes wrong at the operating company, the holding company is protected and not potentially liable. And then if something goes wrong in the holding company, even then, the owners, shareholders, and investors are typically not protected. So you get this kind of double shielding effect. And as your business becomes more valuable, for many people, and I'm in this category, the business assets are probably more valuable than my own personal assets. Then you want to have another layer of protection. And Sprintlaw is set up with this dual company structure, or multi-company structure now, where we have, an Australian company, a UK company, and so on, and then a holding company, for this kind of purpose. And then on the right, we have the trust structure, similar to the dual company structure, but up the top you can see there's some additional entities. One of the things you'll note when you have these models of setting up a company, if there's more than one owner of the company, while the owners, are protected from issues with customers, employees, and things that arise in the business, the individual owners themselves are kind of in business together as co-owners of a company or co-directors of a company. they don't have companies in between each other. So if there's a falling out between business partners, you know, even though you have a company structure, if it's happening at that business partner level, it's still possible that, you know, your personal assets and things are at risk. So often individual owners set up their own kind of third company in this model. It can be done with a single company structure as well, to provide an additional shield from issues with investors or other business partners. And there's also certain tax benefits to having a trust structure. We're not accountants at Sprintlaw, so we don't talk too much about tax things. But one reason a lot of business owners choose to use a trust to operate at least their holding in their company is because, you know, there's benefits if the company issues dividends or pays out profits of the business, you know, to having a trust rather than just receiving it as an individual. So if that's something you're interested in learning more about, it's a good conversation to have with your accountant. They can often set up the trust for you. But for anyone out there who's, again, just getting started, the key message is, if it's a serious business, consider at least having a company, because otherwise, if something goes wrong, you could be on the line. And you know, as the business grows, or if you have larger ambitions, think about these dual company structures and potentially trust structures as well. You know, there are costs to setting up companies. It costs, I think, with us, $900 for, I think, a registration, including all of the government fees and things, as opposed to $0 as a sole trader. So it's not nothing, and you know that becomes bigger if you're setting up two companies, or in this model, you know, there's 3 or 4 companies. But you know, for the potential benefits and risk, it can really be worth that investment. So once you've got your business registered as ideally a company, and you know, you're looking at operating online, one of the first things to turn your mind to is, okay, what are the laws I need to be aware of when I'm setting up my online business? Chances are you're going to have a website of some sort. Most online businesses have their own website. Some obviously will sell through platforms and things like that, but you're likely going to have a website. You're likely going to be putting content, prices on your website. You're likely going to be including messages explaining why your products and services are great. You're going to have discount deals, potentially, if it's goods, offers. You might put reviews up. And then you might do some marketing online. So you're going to be engaging in a ton of activities around your business. As you're setting all these things up, writing your content, preparing all of your graphics, all those sorts of things, you want to be aware, okay, well, what can I do and what can I say, and how can I make sure that I'm not doing anything dodgy when I'm doing all this stuff? I want to make my business look as good as possible, but I don't want to break any laws in the way that I do things. So the way things work in Australia is we have a fairly general piece of law or regulation around misleading and deceptive conduct. And it's really the principal piece of regulation that online businesses should have in the back of their minds whenever you're doing any of the activities I described. And we've got it on screen now. It's illegal for businesses to engage in conduct that misleads or deceives or is likely to mislead or deceive consumers or other businesses. So that's pretty close to the wording that the law has. Which is quite broad. It's not one of those laws that says you can't do this specific type of review, you can't say this specific sentence, you can't, you know, do this specific type of price comparison. It's much broader. It just says you cannot be misleading. And so what misleading means is very open to interpretation, and lawyers everywhere make a lot of money by answering questions from clients. Is this misleading or is it not? But for a kind of lay person's interpretation of what we're really talking about, is someone looking at this and is a reasonable person, not any person, but what we call in law, a reasonable person looking at this and being misled as to what they're getting for their money. Is that happening? And if the answer to that question is yeah, probably, then you're likely to breach the law. If the answer to the question is probably not, then you're unlikely to. And a lawyer will struggle to ever tell you yes or no. All we can do is look at some cases of when things went to the ACCC, which is the key regulator for this, or when things went to the court. And I have a couple of examples on the following slides to give you a sense of, you know, where the line is or where the law thinks the line is. But ultimately, it is very much a common sense test. And so the best thing you can do is just be wary as you're typing things. The law accepts what we call mere puffery, which is an old English term for, it's the law recognizes sometimes we need to use persuasive language. Sometimes we need to say things like, this product is, the best product for, taking away the summer stress. Like saying something like that, a reasonable person knows you're using marketing language. The fact that you called it the best and then you don't have a scientific study explaining why it's the best for summer stress, whatever summer stress is, we're not that strict in terms of the way that we interpret some of the language that's used. But if you are making fake scientific claims or fake pricing comparison tables or feature comparison tables, or putting up fake reviews, things like that are pretty clearly misleading. And that's the stuff that really the law kind of focuses on. Now, in addition to this stuff, if you're in a particular industry, if you're selling children's products online, for example, or you're selling products that have safety hazards and other sorts of things, there may be further industry-specific regulations, and a lot of them will be on available online. Government websites help you identify like what industry you're in and what regulations may apply. But for certain products, if you're selling them online, you need to potentially include additional disclaimers if the industry requires it. And in some cases, you need registrations before you can even sell some of these products. For example, if you're selling products with potential health benefits or pharmaceutical products, there's something called the TGA, which is a regulator that may require registration depending on what you're selling online. There's laws about selling things like tobacco online, and as well as general laws that affect selling things like children's products online as well. So worth investigating that for your business and understanding if beyond this general requirement not to be misleading, there are industry-specific regulations that may apply to you. Just to give you an example, I've talked a lot about this concept of being misleading. What do we mean by that? This is an example of a fine that was issued against Reckitt Benckiser, who are the manufacturers of Nurofen, for a misleading ad that they had. And this is like a picture which suggests that Nurofen's quicker and more effective in treating common headaches, and it looks like it's backed by scientific research. This was basically based on pretty weak scientific evidence, and it was shown that someone looking at this would reasonably conclude that Nurofen is much faster than paracetamol and much more effective at treating headaches. Where if the evidence behind it doesn't support that conclusion, that could be considered misleading. So that gives you a flavor for a kind of example of something that's misleading. Something a bit more smaller scale. This is from the ACCC's website. Is these online reviews, and something that's obviously misleading is posting fake reviews or fake testimonials or asking your friends to write reviews for your business when they never actually used your product or service. That stuff can certainly be misleading. But we've got here, an influencer situation. A hotel chain pays an influencer to tweet that she loves staying at one of their resorts. However, the influencer has never actually been to the resort. So that's very likely to be considered false, misleading, and deceptive. So this stuff is fairly black and white, and you can see what we're talking about. Writing things to promote the business that are just not true, really can be considered misleading. And there's another case I don't have in this deck, which happened not too long ago, but I found quite interesting. People would have seen, for software businesses, those comparison tables comparing one business to others. And a couple of sites have gotten in trouble for, the criteria that they chose made obviously a certain sponsored business look better than all of the competitors. And so things like that, again, give the wrong impression and can be considered misleading. So keep all of that in mind as you're writing content. If it's very high stakes, very important, you can ask a lawyer to check it for you, and we'll be happy to tell you whether we think it's high, medium, or low risk of being misleading. But it's obviously not practical to check everything that you publish online through a lawyer, so it's just worth having a good understanding of these laws and ultimately using that common sense test when you're publishing content. Now, just turning over to intellectual property. So, you've got your business set up. You've got a good understanding of how you're going to populate all the content on your on your website and so on. How are you going to protect your business's brand and other forms of intellectual property? And so when we're talking about intellectual property, we're talking about those intangible, as opposed to physical property, intangible assets of your business that are usually quite important to its value and its operation. And the most obvious one of those things is your brand name. Your business is likely to have a brand name. It'll be the name that you trade with. It'll hopefully, if you are able to secure a domain name, it'll be matched with your domain name, and it'll be the thing that you will be trying to build a reputation for. If you're a business that does more than just sell products or services online of third-party vendors, but you actually have your own products that you've created, your products themselves may also have brand names. And maybe it's a skincare product with a brand name, or maybe it's a toy or some other good, or maybe it's a service but it's got its own kind of branding to it. Those things are also important, and you may want to build a reputation around those sorts of things. The legal way you protect brands is through what we call trademarks, and a trademark is a registration you can make in a particular country, in a particular industry, that gives you the exclusive right to use the thing that you have registered. And it means that no one else in that industry can use that term, that branding, in association with their goods and services to promote them without your permission. Now, they can talk about you in a news feature or mention you online, but if they're trying to promote goods or services, make money off something, they need your permission in order to do so. So to give you an example, Sprintlaw has registered a trademark for the word Sprintlaw, this little S-shaped logo. We've registered it in the legal class or legal industry. We've registered it in Australia, in the UK, in a bunch of other countries all around the world. What that means is nobody else in Australia can use the word Sprintlaw or anything objectively similar to it, Sprint Legal, Sprint Lawyer. It's not just an exact match. It can be stuff that's similar to it, in association with goods and services in the legal industry in those countries. So now someone could start a restaurant called Sprintlaw that sells coleslaw or something. That might be a terrible name for a restaurant, but it's not necessarily infringing our trademark in the legal industry. But in the legal industry, we have pretty strong protections for what we're doing, and that's very important because we spend a lot of money on our website, on our branding, and then building a brand and goodwill over many years. So we want to make sure it's secure. So the same goes for your business. What's your business name? What's your key brand? And you can see here, Nurofen is its own trademark, separate from the business name, Reckitt Benckiser. So it's not just your business name that you're trademarking; it's your core products as well. Nurofen obviously wants to own Nurofen, and you can see here they don't have Panadol in this diagram because Panadol is itself a registered trademark, and there's a ton of potential issues where one of them would be trademark infringement using the Panadol brand to promote their own goods and services. And so these are the kind of reasons that you want to make sure you own your trademark. And really, it is, I think, for an online business, once you got your business structure sorted, trademarks are kind of towards the top of the to-do list, because if something goes wrong, some other person starts trading under your name, or maybe you haven't even checked yet, but there's another business out there with a similar name to you in your industry. You spend a year or two building the business, building up the brand, building up all the branding, only to get a letter from someone saying, this is my brand, and if you don't cease and desist, I'm going to sue you, and et cetera, et cetera. That's a terrible position to be in, and sadly, it's of the legal issues we see happen in small business, the trademark issue is, I'd say, in the top 3 most common issues. Someone started a business using a name that they couldn't really use, or someone started a business and then someone starts copying them, and there's not as much they can do because they didn't register that kind of early trademark. So if you haven't already, definitely look at doing it. Again, we can help you register it. There are ways to do it yourself as well. It's not that expensive. For a single trademark in a single class, under $1,000, it can be even cheaper. And it's something that lasts for 10 years. So it's really one of those kind of key setup items. Domain registrations are not really a legal thing, but they are something that people will be aware. If you're registering a website for your online business, You can go to a domain registrar. There's plenty of them online. GoDaddy, Squarespace, which also offers websites, are some common ones, but there's many, many different ones. And what you're doing is kind of renting from the provider of domain names the exclusive right to use that domain name, so that when someone goes to that website, they're going to be redirected to your site. So obviously important to secure the domain name. Even if you get the trademark, if someone else has the domain name, it can be quite difficult for you to get it off them. Even if you have the legal rights to the trademark, the way that domain name law works, if the person registered the domain name prior to you existing, then they don't necessarily have to sell it to you or transfer it to you. It's not that simple. So it is definitely worth doing domain checks before you settle on your name. And you might want to do domain checks in multiple countries. It's an issue we, again, see very frequently. Businesses will start out in Australia but plan to operate in other countries, only to find that they couldn't get a local domain, or someone else has a trademark in another country, and it makes it quite difficult to expand there. Sprintlaw has had issues of our own in that respect, and ended up having to settle some domain disputes in some other countries we wanted to expand to. So it's again a common issue, and for those with international ambitions, something to think about. So get the trademark, get the domain, make sure it's available, register those things. The other types of IP we have on screen, we've got copyright. Copyright is a form of intellectual property that protects original works recorded in material form, and it's originally designed to protect things like music, art, plays, books, literary works, dramatic works, musical works, film, these sorts of things, creative works. And the idea is the creator of those works owns those works, and if someone else copies them and it was their original work, they could potentially be infringing that person's copyright. Now, unlike trademarks where you go apply online for a registration and a registration number, copyright has no registration process. The person that makes an original work, provided it's original, which again has what you might call common sense legal term, if you make an original work and it's recorded in material form, and that could be digitally or on a piece of paper or whatever it is, the moment it was created, the author that created it owns it. So if you write a blog post, the author of the blog post owns that blog post, the second they press full stop, if you will, at the end of the blog post. If you create a graphic design, the second the design's finished, the designer owns that piece of work. This is important in your business because you may be creating assets, designs of all kinds for products or services. And first of all, if you're paying someone to design stuff for you, you want to make sure that you own it, because by default, if there's nothing to say otherwise, as I just said, the author owns it. And so if you've paid a designer to design something for you, the designer actually owns the design they've created. If you pay a copywriter or a writer to write something for you, the writer owns it. Even if you have an employee, if you don't have a contract with them, the employee owns it. So the way to get copyright back to your business is through contracts. And this is why lawyers are always talking about the importance of getting contracts. If you've got a graphic designer doing work for you, you should have a contract with them. And the contract shouldn't just say, I'm going to pay you, because just paying someone is not enough. It needs to say, I'm going to pay you for your designs, and you agree by me paying you that I will own the full rights to anything you design. And when we say I, if you're a sole trader, it's literally you, but ideally you're a company. So it's I, the company, my company entity is going to own anything that you create. And anything you create in the past or the future, if it's related to my business, it's mine. And that's kind of how this is worded legally. So there are these documents that we often prepare for businesses called IP assignment deeds. They're really short 2-page documents, almost like a release form. And we suggest that they get all their designers or creatives to sign these things. You don't have to use those documents. Another way that is commonly done is you'll have a contractor agreement or a terms and conditions or some contract with the creative person. Inside that contract, it will just have a paragraph that says kind of what I just said. Any work we pay you for will be owned by us. It doesn't really matter what document you use. You need to, though, have in writing, signed ideally by both parties, something that says, you know, you hereby transfer the copyright to us. So if you're thinking about any creative works, it may not just be graphic designs. It can be creative blog content. It can be presentations like the one I'm doing now. Anything that's original and is some form of original work that's recorded material form. If it's important to your business, just make sure you've got a contract transferring it. So that's copyright. Now, the other aspect in which copyright comes up is, of course, on your website, you may be doing blog posts or social media posts or various other ways of promoting your business, or products and services. And you may be, and this applies to trademarks too, wanting to use other people's works, other people's trademarks to promote your goods and services. You often see people posting clips with other people's music on it, or clips from movies and things like that. You do have to be aware of copyright when you do this stuff. If you're writing a blog post and you've copied an image from someone else's website, people often think it's like in university or in high school, whatever. If you reference them, you're not plagiarizing. That's not a legal concept, plagiarizing. Referencing does not get you out of copyright infringement. You actually have to ask permission from the owner of the creative work before you use it. Now, a lot of the social media apps, Instagram and TikTok, have gone and done like deals with big music companies. And so that's why like you can use famous songs inside those apps, but you can't use them on your website because it's off platform. Instagram and TikTok and those platforms are paying a lot of money to enable the usage on those platforms of a lot of this creative work. So do have a think about that. A lot of people will use stock images or stock music for stuff they create digitally to avoid the issues around copyright. If you don't want to use stock stuff, and if you're not doing stuff in the kind of safety of these platforms that already handle some of the copyright stuff for you, just make sure you got permission. Otherwise, there's a risk that you are infringing their copyright. And again, if they own it and you use it to promote your services without their consent, there's a potential for liability for your business. And the same goes with trademarks. That's, again, to reemphasize the point why your friend didn't mention patent law there. So those are the two big forms of IP. Just to briefly touch on NDAs. NDAs, people have probably heard of these things, non-disclosure agreements, also called confidentiality agreements. These are documents that you can sign with really anyone. And when the document's signed, it says, you, the person signing this, agree that I'm going to tell you some information. And once I tell you it, you got to keep it a secret. You can't tell anyone else what I told you. And if you do tell someone else, I can sue you for breach of this document that you just signed. So it's not really a form of property, these contracts, but we include it here because oftentimes you'll find that you've got an idea. Maybe it's for a product, maybe it's a formula, maybe it's a business idea, and you want to talk to someone about it. Maybe it's a software developer, maybe it's a manufacturer of your goods offshore, onshore, and you're a little bit nervous that when you share information with them, they're going to steal it and keep it for themselves. Now, trademarks aren't going to help you much here because trademarks are about brand names. Copyright may or may not help you depending on what you're sharing with them. If you're just sharing with them ideas and information that isn't like a actual blog post or creative work, if it's not recorded in material form, it's just your ideas. Copyright famously does not protect ideas. So the NDAs are a really important tool for protecting kind of secretive information or stuff that might not be covered in any other way, but that you are worried about. So again, pretty straightforward. I think in our Sprintlaw membership, we have a free NDA that you can just create an account, log in and make. Pretty important and handy to have a template NDA for your business, just so before you're sharing information with potential suppliers or anyone else, you can get them to sign one of these documents, and then they're obliged to keep it sort of under wraps, or they suffer legal risks. Now, you might think to yourself, I'm never going to bother going to court if someone steals my information. It's going to be too expensive, etc. And if you're in that bucket, still it's worth doing an NDA because and there's studies that show this, the act of signing this NDA document actually changes how people behave. The threat of potential legal consequence causes people to treat information with more security. So these documents have very strong practical purposes, even if you don't think you're necessarily going to go out there and sue everyone. It's one pager, it's simple, and it's a good part of business practice to get them signed. So do think about using those docs. I won't talk too much about patents or patents because we don't have much time. These are really reserved for inventions, very sophisticated creations that push forward human progress through science. So if you've invented something and you're going to be selling a commercialized version of your invention online, maybe it's a pharmaceutical product or maybe it's a physical device, you might want to get those things registered before you do so. But if you're in that category, I'd suggest reaching out to a specialist patent attorney. So we've covered a lot of the intellectual property stuff. Now just moving into documentation, contracts, and these sorts of things. So we have this fairly dramatically titled slide, Contracts Are the Lifeblood of Your Business. And I talked about trademarks being a big issue that we see. Another really big issue, and this is probably the biggest issue we see, particularly for smaller online businesses, is no documentation of any sort covering their key relationships. Now, there's not, in most cases, a legal requirement for you to have many of these documents. And you can operate your business without them, or you can operate them downloading some templates off the internet. But these documents are really quite important, and particularly the one I've highlighted and read on the right, your customer terms and conditions. For an online business, this is probably your most important kind of day-to-day document. So you kind of want to make sure that it's correct. And what a terms and conditions does, it's a contract between, if the business in the middle is represented as a house, you, the business, and your customers. And it says, when you buy our goods or services online, you agree to XYZ terms and conditions. You agree, first of all, that delivery may take this long, but there could be delays. You agree that you'll pay this much upfront. You agree that we have this kind of refund policy, but only in these situations does it not apply. You agree that if something goes wrong and you get injured in the process, or there's some problem with the product, we're not going to be liable for all of your medical bills for the rest of your life. We're only liable up to this amount. These are the kinds of things you can put in your terms and conditions. And you can see there, just even in those 4 concepts, and there's many more concepts in terms and conditions, we have in there the payment terms. So you're securing your revenue streams. Maybe it's 100% upfront payment always, but if there's any form of split payment, you essentially will have a legally binding arrangement to get paid. Refunds, a big source of disputes. How does it work? Is there enough detail in there? A lack of ambiguity to make sure that if a refund scenario comes through, you have clear grounds to either refuse or grant a refund. And again, we see a lot of businesses try and write their own refund policy, and they don't cover off a lot of details that could be included in there, and ultimately end up suffering the consequences of disputes around refunds, which ends up with bad reviews from customers and potentially money wasted dealing with it. Shipping information, again, very common for goods businesses. How does that work, and what happens if there are issues? And then the liability limitation is a risk thing. If you're selling 5, 10, 15 products online, maybe you get lucky and nothing goes wrong. But the longer your business exists, 20, 25, 30, 50, 100 customers, the chances statistically are that at least one thing is going to go wrong. And your terms and conditions may be irrelevant 95% of the time because nothing goes wrong, 99% of the time when nothing goes wrong. But in that 1% of the time where something goes catastrophically wrong, they can be the difference between a business ending and the person having no claim and not even bothering to contact you once they've read your terms and conditions. So they're quite important. There's quite strict laws. We talked a bit about the misleading and deceptive conduct laws. There's some laws around terms and conditions in Australia as well for businesses that sell to consumers, which is very broadly defined and is likely to include the majority of businesses, because consumers includes actually small businesses. So if you sell to consumers or small businesses online, your terms and conditions have to comply with something called the Australian consumer laws, and your business has to comply with the Australian consumer laws. And these laws also require you to have reasonable terms and conditions, to not have too aggressive refund policies, to have reasonable limitations of liability, et cetera, et cetera. And if you put stuff in your document that breaks those laws or is inconsistent with those laws, you can actually be fined, penalized, and the terms and conditions can be deemed invalid. And those laws in Australia were updated pretty significantly about a year ago. And the consequences have become a lot more severe because the ACCC is realizing a lot more business is happening online, a lot more terms and conditions are being buried in fine print that no one reads, and so it's getting a lot more strict on people relying on the fine print, if you will. So get a good terms and conditions document is a key message. It's one of your most important documents for your business. There are other contracts across your business that you might want to put in place. Again, you got to think about that matrix that I keep coming back to. There's a lot of money you could spend on these contracts. What's it worth spending on? In most cases, this one is worth spending on. If you have business partners, that's another one you probably want to spend on to avoid a dispute with your business partners. You can have what's called a shareholders agreement for a company. And it's like a business partnership agreement. What happens if one of us wants to leave, one of us wants to stay? What happens if we have a dispute? What if one of us wants to sell, one of us doesn't? How's that all going to work? And can we agree up front so that if the business circumstances change, things will still be able to operate? Then we got your supplier agreements. Maybe if you're a goods business, you have a drop shipping supplier or some other goods supplier. What are the terms of those agreements? Are you just going to sign what you're given by the supplier, or is there room to negotiate or at least understand how it works? I talked at the beginning of this presentation about value lawyers can provide here in terms of making sure that if the supplier is delayed or provides faulty goods or defective goods or doesn't do what they promised, you get discounts, refunds, and so on. That may not be in their standard terms and conditions. So either check that yourself, ask questions about that, or if you can afford it, consider getting legal review. Maybe not for every supplier if you have many suppliers, but maybe it's just your biggest suppliers that are most critical to your business. So that's another area where contracts can be really important to just check before you sign. And then you might have service providers. Maybe you've got contractors. Maybe you're selling through a platform like eBay or Shopify. What are their terms and conditions? What are you signing? And are you going to comply with them when you're operating your business? We've had customers on Shopify selling stuff online, inadvertently breached the terms and conditions of Shopify and had their website suspended by Shopify. So I think you want to make sure that you're not breaching those terms and because it can have serious detrimental impacts on your business. And again, with your contractors or other suppliers, you just want to make sure you know you're getting what you paid for, etc. So these are the different types of contracts that might come up in your business. If you end up with affiliate or referral partnerships and there's commissions paid, again, you might want to have something in writing explaining how the commissions are calculated, if they're payable, and we sometimes see confusion around how that stuff works, where a good document, contract terms and conditions can really set out how it's meant to work and avoid disputes. I've just noticed we've had a question through the chat. Given the searchability of online businesses, can an Australian business sell to someone in another country but only comply with Australian law? We see so many UK and US companies marketing to Australia via meta platforms. Can we do the same? Look, it's a really excellent question. And the answer is technically no. And technically, when you see a lot of these businesses from other countries not set up in Australia but selling in Australia, they are breaching regulations. The way it works is, and I can talk from the Australian side, and the laws are similar in other countries. I'm obviously not qualified in every other jurisdiction, although we do operate in the UK. The law in Australia is if you're a business from overseas conducting business operations in Australia, engaging in trade or commerce, you must be registered here. If you're making income, typically you're going to tick that box and you've got to have a registration in the country. And same goes for Australian businesses selling in the UK, in the US, in other markets. If you're selling there, making money there, technically you're meant to have some kind of registration in that country. Now, lots and lots and lots of businesses don't do it. And what they're implicitly doing is thinking about this risk matrix. If 98% of your customers are in Australia and you happen to ship a couple over to the UK, it's so small scale that maybe it's arguable if you're even really operating there at that scale. But if you are extremely tiny, it's unlikely that you're going to get fined or you're going to get in trouble with the regulator. But there is a risk, and so. But it is very expensive to set up another entity and understand the laws of that region. So what you see a lot of online businesses do is at small scales, they might ship internationally. It's a bit risky, but they'll do it for a little while. And then as their organization gets larger, the risk starts to move up towards the red section, and they'll at that point properly set up their entity and start selling there. Now, as lawyers, we're going to advise you from day one, if you can afford it, get set up. If you can't afford it, then just be aware of this risk matrix. If you're doing it, if you're selling overseas, you're technically going to be likely to be breaching a law of that country, which requires you, if you make money in that country, to be registered. And so if you do it more than occasionally, the risk kind of goes up, and you really should set things up. And, obviously we're a law firm, so we don't take any risk at all. We, from pretty much day one in the UK, we set up our subsidiary entity there, and we weren't, even though we were doing some of the work from Australia in the early days, we weren't just doing that from our Australian company. We set up a proper business there. So really good question, and one of the most common questions we get from e-com businesses, and that's probably the most pragmatic answer I can give you in terms of yes, you do need to comply. When you see people not complying, that's how they're thinking about it. Now, the other aspect is your terms and conditions. If they're all written to be compliant with Australian consumer law, well, in the UK, there's something called, the Consumer Rights Act. So it has its own set of consumer laws. So you often need to change your documents as well. And it can be a little bit of a cost to expand into other markets. When you sell through platforms, sometimes the platform takes care of the international terms and conditions. eBay, for example, has its own, it does all of the infrastructure for you. So it can be a way to ship internationally. But a lot of people that are selling on the Meta platforms, and I'm not sure if you're referring to Meta Marketplace in your question. I'm not 100% sure how Meta's marketplace works, but I don't think it works the same way as eBay. I think there can be issues if you're shipping internationally through that platform. So yes, definitely something to be aware of. Just finally moving on to data and privacy. So we've talked a lot about the documents you need for your online business. One final document that is extremely common and in many cases required is a privacy policy. And a privacy policy is a document people would have seen all over the internet. It's a document that you put on your website that explains to people when you're collecting their personal information what you're going to be doing with it, what you're going to be using it for, and how they can contact you if they got questions about it, and which third parties might have access to it. And in Australia, we have something called the Australian Privacy Principles and the Australian Privacy Act, which in many cases requires those disclosures. And in the UK and Europe, we have something called the GDPR. So for businesses that are selling overseas, as we were just discussing, there's even more stringent requirements. And that's why you see those cookie policies, not an Australian requirement, the cookie policy, it's a European UK requirement, but you see those all over the internet popping up. Hey, we're tracking your movements and your data while you're on our website as well. So Australia has quite a big exception for small businesses. So businesses with under 3 million of revenue, actually there's no requirement to have a privacy policy. It's only when you reach above 3 million that you're required to have a privacy policy. However, that law is pretty likely to change in the next year. There's a lot of discussion of that. And B, for businesses that have ambitions to grow beyond 3 million, it becomes very complicated if you didn't have it from day one. So we suggest all businesses just have a privacy policy from day one. The other thing to be aware of, if there's a data breach, so you're holding people's name, address, emails when they make orders on your systems, and you're hacked as a ransomware attack or something else, in many cases you have a legal obligation to inform the government regulator that this has happened. and also to inform the people affected that their information may be at risk as well. And this is, again, a legal obligation, which for smaller businesses is a much lighter requirement, but may be abolished soon. But certainly for businesses that have grown beyond that point, a very serious issue. So I would just suggest for those that suffer a data breach, first of all, best thing to do is to avoid it and have good security and be careful about the way that you're storing information and potentially get some cybersecurity help. But in lieu of that, if you do suffer a data breach, definitely worth getting some legal advice on what you may or may not need to do, who you need to tell, and be aware of that. And the key message here for this data and privacy stuff is make sure you've got the policies in place, make sure you're taking reasonable steps to protect people's personal information. And then if something goes wrong, just know you've got some legal obligations to do something, and you probably want to get some advice at that point. We got a question from Pamela. I have an ABN. Can I start an import-export business bringing or sending goods from Vietnam to Australia? You can start such a business. You have a few considerations, which is maybe a nice way to round up some of what we discussed today. For that kind of business, if you just have an ABN, sounds like you're probably set up as a sole trader. So your first question would be, do you want to be a sole trader, or might you consider setting up an ACN or a company number? It might be a better structure for the business. Otherwise, it can be a bit risky when you're selling into Australia. With the person that you're importing from, or from overseas, or potentially exporting to, you're going to want to have some contracts with those suppliers. What are you getting? What quality will they be? What if there's delays? What's the price? What's the liability risk, et cetera, et cetera. So there are some contracts you're going to want to get in place. Then if you're on selling the goods to somebody, what are the terms and conditions or contracts by which you sell those goods? So those are some considerations. And then you've got your brand name and a few other things we covered today. So the answer is yes, you can certainly do that business, and there's many import-export businesses. And hopefully some of the content that we provided in this session helps you think about that. That is the end of this webinar, coming right up to 2 p.m. I hope people have found this really useful. If you do have legal questions, do reach out to our team. Someone asked if there'll be a copy. We will be shooting through a copy over to your emails, and I hope people have enjoyed this. We do these every month, so if people have topics they'd like to hear, please do request them to our team. Otherwise, keep an eye out on your emails for invites to future sessions, and thank you so much for attending. See you later.